Court in Pretoria declared Dudu Myeni a delinquent director for life. This is for her conduct while leading SAA's board of directors. However, after 3 years, Myeni can apply to suspend the declaration of delinquency. What does this then mean for leadership, accountability in business, and especially for our state-owned entities? I'm joined by corporate governance advisor Peter Goss for more in Johannesburg. Very good morning to you. What implications does this have on leadership in the country?
Jane, I wish we could be seeing more of this in the private sector, which are major players in the game of work-directed delinquency. We hope to see it in the high-profile matters around Tonga Hewlett's at some point in actions. We hope to see actions around Steinhoff at some point in time. But let's look at the case before us on SAA's former chairperson being found liable for delinquency. It is quite a groundbreaking decision by the court, the decision that it should be a lifetime ruling of delinquency, and as you rightly point out, that can be appealed right away, which she intends to do, and secondly, she can request that the suspension, that it be suspended after 3 years, but she must have served 3 years as a delinquent as we go forward. What is troubling in this matter is who launched the case. The case was launched by civil society, and that is very troubling. In the law, the people who should launch an action for delinquency are the shareholder, number one, number two, trade union representatives, number three, the fellow directors themselves, and number four, the company secretary. Now, look at those people who have the power to say, you are not running our company effectively, you are not being a responsible director, you're not executing, and this is what a delinquency ruling means, you're not executing your fiduciary duties of care, skill, and diligence, and that's why you're found guilty. Where was the shareholder? The shareholder in this case was the minister that oversaw SAA. Why did the shareholder not lodge this case? Why did it take civil society, who even the defendant has argued had no legal standing to register a case of directed delinquency? So I think the problem is that shareholders and company secretaries and trade unions and those authorized to initiate actions like fellow directors are really not serious about holding people to account. So
is this also an indication of how many companies have been infiltrated by those with sort of nefarious intentions?
Absolutely. You find a cronyism that has developed amongst these parties that should be lodging cases against directors who are not conducting their fiduciary duties. That's the accusation. The accusation is you are not fit and proper to serve as a director because you did not carry out your fiduciary duties, and therefore you're not fit and proper. Now, how can fellow directors not see this? How can a shareholder over a state-owned company, a single shareholder, not see this? And there is one single one called a minister.
I mean, she was cited for her political clout, and that's obviously what's made her attractive for other boards. I mean, how do we clean up this mess, not only, when it comes to government entities, but in the private sector too?
We appoint fit and proper directors by conducting proactive processes, due diligence processes, long before they come on board to assess their competence. The ruling in this matter said the defendant was not competent to serve in that position, was not fit and proper to serve as a director in the future. And that means we must be more intelligent in assessing candidates for directorship. Number two, we must make sure that boards take responsibility for assessing their own performance, particularly the performance of board chairpersons, and be robust and candid with them about non-performance. Thirdly, we must confront them when they behave in a manner that is falling foul of their fiduciary duties and the law that governs the company, the organization that we are governing. So here what we've had is the real essence of a corporate governance failure, when a court can rule that the chairperson of a board of directors has failed in their fiduciary duties. What then is the question about the board? Well, the answer is in the media. Look at the struggles of that poor organization right now. It is in business rescue, and they've connected, the case has connected the current position of the organization with its past behaviour of its chairperson.
Yeah, this must stop. Peter Goss, good to talk to you.